Good afternoon and welcome. My name is Jennifer Caniglio and I'm with Corporate Counsel Business Journal. We are thrilled to be working with our partner NAM, National Arbitration and Mediation, to present today's webcast, Resolving Coverage Disputes in Mediation, with Richard P. Byrne, Commercial Specialist for NAM. Richard P. Byrne, Esquire, has been serving as a mediator since mediation first came on the horizon as a cost-effective means of resolving litigation and other disputes. He is well respected professionally and has a reputation for bringing the most contentious disputes to full and final resolution. A strong proponent of alternative dispute resolution and a certified mediator with the United States District Court since 1992, Richard brings more than 25 years of ADR experience to NAM's New York Metro panel of neutrals. He has successfully mediated issues in a wide variety of specialty areas, including commercial disputes, employment discrimination claims, employment contract disputes, wage and hour FLSA claims, construction matters, complex personal injury and property damage claims, insurance and reinsurance matters, risk transfer disputes, and life, health, and disability claims. His legal career of more than 35 years brings an added dimension of expertise to matters over which he presides. Richard has earned the distinction of being voted a top 3 mediator in the United States for the 6th straight year in the 2020 National Law Review Best of Survey. Further, he was ranked a top 10 mediator by the 2019 New York Law Journal Best of Survey for the past 5 years. He was also voted a top 3 mediator by the 2018 Corporate Counsel Best of Survey, and for the 3rd straight year was named a National Law Journal Alternative Dispute Resolution Champion. During this webcast, we encourage you to ask questions and fill out the survey with your feedback at the end. It all can be found as icons at the bottom of your screen. And now it is my pleasure to pass it off to Richard. Richard?
Well, thanks, Jen, and welcome, everyone. I'm very happy to be with you this afternoon to discuss our topic of resolving insurance coverage disputes in mediation. I hope you and your families are doing okay, of course, as we are finding our way through this very strange and unsettling time. But at least for the next hour, we can talk about something near and dear to my heart, and that is resolving insurance coverage issues. Let me give you a little bit of a sense of how the program is going to roll out. I'm going to first look at various scenarios in which insurance coverage questions may arise and talk about the types of issues which may be encountered in each of those scenarios. Then we're going to take a look at why mediation is an advantageous means of resolving insurance coverage disputes and which are the best means to employ in the context of the mediation process. So let's begin. 4 basic scenarios in which insurance questions may be encountered. First-party claims, third-party claims, inter-insurer claims, and what I call underwriting claims. So I want to take each of those in turn, and as I mentioned, look at and identify some of the issues by way of example that you may be faced with in each of the 4 scenarios. So we'll start with first-party claims. What are we talking about here? We're talking about property losses, business interruption claims, more specifically, fire losses, water damage claims, storm damage claims. You know, the issues being encountered are what's within the scope of coverage, what's outside the scope of coverage, the valuation of the loss, the cost of repair. For example, dealing with replacement cost coverage versus ACV or actual cost valuation. I can give you a quick example from my experience, and although it seems like yesterday here in the New York metro area, of course, we were struck by Hurricane Sandy about 8 years ago. As you might imagine, lots of first-party litigation ensued between homeowners and their insurers concerning these issues. Primarily, and interestingly enough, because even though we do refer to it as Hurricane Sandy, it was actually a water-driven event for us more than a wind event, but these mediations in which I was involved, and frankly, I lost count. It was certainly well over 100 of them. We were focused on wind versus water. Why? Because wind would be covered under a homeowner's policy, any damage due to wind, but water or flood coverage was generally excluded. So there was a big battle, as you might imagine, in the context of these various mediations over the categorization of the type of damage, and that ultimately drove what was able to be recovered or not recovered for the homeowners in each instance. Another example of first-party claims, life insurance claims, claims within the 2-year contestability period. Did the decedent, for example, fully disclose their health condition when they applied for the coverage? And if not, would that information have been material to the underwriting of the risk? As you might imagine, when you're dealing with life insurance claims in the context of mediation, it can be a very, very emotional setting. You've got the widow or the widower or perhaps the children there in the room. And we'll talk a little bit later on in addressing mediation strategy generally, how you deal with emotion and anxiety in the context of mediation. But of course, life insurance being a terrific example of where you've got folks who are really, really emotional about the situation. Same is true with disability claims, another type of first-party claim. What are we dealing with in the context of disability insurance claims? We're looking at issues concerning the insured's ability to perform their occupation, their own occupation, I put that in quotes, or depending on the policy, any occupation. And the policies differ in that regard, and that leads to great and in-depth discussions over a person's ability to perform a job function. We debate what the financial consequences of being unable to perform that job function may be. What does the policy allow as far as recovery? How the loss is documented. And again, this is just a flavor for the type of issues that you see in disability insurance claims as a subset of first-party claims. Let's talk a little bit about third-party claims. What are we speaking about here? Well, to start, general liability claims, or CGL claims, commercial general liability claims. You may be familiar with that term. We're often looking at underlying personal injury or property damage claims in the context of premises liability. Here in New York, where I am home-based, we have a famous or infamous statutory scheme you may be aware of called the New York labor law, which addresses legal obligations in the context of a construction accident leading to personal injuries to a worker. It can be very, very contentious for lots of reasons, not the least of which are the insurance coverage issues that are driven by New York labor law claims, and we'll talk about that in a little bit. But also in the context of general liability claims, we're talking about subrogation matters, we're talking about third-party auto claims, we're talking about construction defect claims. Often we encounter in all of the general liability claims the claimed application of policy exclusions. These are the types of insurance coverage issues we're going to see. Is there a particular exclusion that an insurer claims applies here? How is the other side reacting to that? There may be alleged violations to conditions to coverage, so that an insurer is arguing that the coverage was unavailable in the first instance because of a failure to satisfy a particular condition to the coverage. Risk transfer is a huge issue in third-party claims. Why? Because by its terminology, as you may have gathered, it's one party looking to transfer the risk of loss to another party. That can be via additional insured status or claimed additional insured status. It can be through contractual indemnity. We're talking about tenders of defense and indemnity. We're talking about the duty to defend. We're talking about the issues that are inherent in one insurer or insured looking to transfer the risk and responsibility to another insurer or insured. And as you might imagine, that can become quite a contentious issue in the context of a mediation. New York labor law claims, which I mentioned a moment ago, are generally rife with risk transfer issues because there's an awful lot riding on whether or not one party can transfer the risk of loss to another, because under our New York labor law statute, under particular sets of circumstances, an injured construction worker can claim absolute liability against an owner or a general contractor, meaning that the worker's negligence does not come into play, nor their comparative fault. It is an absolute liability statute, and therefore a lot of what we argue about in mediation in the context of New York labor law claims is who is going to bear ultimate or first-tier responsibility between the owner, construction manager, general contractor, subcontractors. And again, as you might imagine, it becomes an issue that is focused on very, very intently, because that's what allows us then, once those issues are grappled with, to begin the negotiations with the plaintiff on his or her damages. Construction defect claims, again, rife with insurance coverage issues. What are we talking about in the context of construction defect, or sometimes we shorthand it as CD claims? You know, we're talking about the construction of a townhome development or a condominium project in Manhattan, where unit owners ultimately purchase their homes, their apartments, and come to find that the construction allegedly was subpar. And then they begin, of course, the process of suing the developers, the general contractors. And not only are we looking at issues of risk transfer, but oftentimes, because these issues can span time, we're looking at whether or not there was an occurrence under an insurance policy. How many occurrences were there under the insurance policy? How long did the damage last for? And are there more than one policy or policies involved? There's also tremendous battles over what are called the business risk exclusions, which generally preclude coverage for poor workmanship, but not the damage that may have flowed from the poor workmanship, which can be a pretty tough thing to slice at times. So again, in the context of mediation, we're addressing all of these as part and parcel of trying to get the underlying construction defect claims resolved. Another type of third-party claim, some of you may be familiar with, professional liability or directors and officers, E&O, D&O types of claims, right? Claims against professionals and business organizations. Different types of issues we're looking at there from an insurance coverage standpoint. We're looking at prior notice, all right? Generally, because these policies are not occurrence-based, as we most likely will see in the commercial general liability world, these are claims-made policies. It's a different trigger of coverage, and therefore one of the key issues that gets examined and debated as to when the claim was first made. And as a subset of that, was there an act, error, or omission in the performance of quote unquote professional services? We can have a big debate over whether or not a certain business activity or professional activity, in fact, constituted a professional service for purposes of invoking this coverage. Sometimes we have combined mixed claims between general liability and professional liability. We see that most often when you have design professionals, architects and engineers that may have been involved in the design and construction of a particular project. A claim against a design professional could have a mix of both general liability and professional liability attributes. And then, of course, we've got the two insurers for this particular design professional battling over who owes the coverage obligation at the end of the day. I want to give you one more example in the third-party liability context, and that's employment practices liability coverage, or EPL coverage, as it's shorthanded, where we've got issues of discrimination, workplace issues where someone is concerned about how they have been treated, whether it be from a sexual harassment standpoint or otherwise, and that body of coverage has its own inherent insurance coverage issues, oftentimes dealing with, well, is there coverage for the bad actor, right, as opposed to the employer that may have been aware or allegedly aware of the conduct of that particular person who is the focus of the litigation. So again, my purpose in walking you through some of these types of claims is just to give you a flavor for how important insurance coverage is in the context of litigation generally, and for me, in the context of mediation specifically, because at the end of the day, I'm looking to find who is going to be providing me with funds to try to settle the case. And that's why I've got to confront these issues among and between insurers, among and between their insureds and insurers, all with a goal of trying to figure out, all right, who is going to help me fund this settlement at the end of the day, and how do I best secure their participation? Inter-insurer claims, all right? This is number 3 on our list. For example, priority of coverage, all right? This is, as the category denotes, inter-insurer claims. These are battles among and between the insurers where the insureds themselves may not be involved. So for example, battles over other insurance clauses. That's a priority battle. Whose coverage comes first? You may think that's a pretty easy issue to address. Really is not. Turns on a matter of the language of the particular policy, the law of the jurisdiction interpreting that particular clause as opposed to the competing clause, and you spend an awful lot of time ferreting this through. We may find insurers battling over priority because one argues that his more broadly worded policy should apply in a secondary position to that insurer whose policy has the more specific coverage. For example, we may have a project policy that was issued for a specific construction project by an insurer, and we may have a general liability policy out there for one of the contractors on the job. Well, there's going to be a battle between those two insurers over whose policy has to respond first. Is it the more specific policy that was issued and premium was paid to provide coverage for that specific project? Or is it going to be the more broadly worded, more enveloping policy that was issued to the contractor on a general liability basis? Allocation of loss is another priority of coverage battle between insurers. Generally here, we're looking at environmental claims. It might be asbestos. It might be lead. It's issues concerning coverage for ongoing losses with continuing damage, where we don't have a discrete accident or a discrete occurrence, and the insurers are having a debate over who, along the timeline of the loss, has the responsibility and in what proportion to the others. And at the same time, again, and this is all very driven by jurisdictional issues, we've got an issue of horizontal exhaustion versus vertical exhaustion. And again, you might think there are answers to these questions easily available. There are not, because the insurers have endeavored through the years to try to manage these long tail exposures. So they have modified their policy language through the years. So you may have older language in the earlier years in a debate with more recent vintage language. For example, we spend time looking at the application of non-accumulation endorsements, where some of the insurers look to build a wall before their policy incepts relative to any ongoing risks or exposures that might have been underway at the time they came on the risk. And then we get into a big discussion over whether or not they were able to achieve their goal, whether it's enforceable, whether there are other consequences from having that language out there on a bigger picture. And again, all of this is in the mix, in the context with the underlying environmental damage claim, as we're looking to try to get that underlying claim resolved. Another classic inter-insurer claim, primary versus excess, right? Maybe that's the most classic. Late notice being a big issue. The excess carrier says, hey, wait a minute, we never knew about this case. You're calling us on Friday afternoon at 4 o'clock as the case is about to go to trial. We're not going to stand up for this loss. Our rights have been prejudiced. We haven't been able to participate effectively. You knew full well that you had an excess exposure here, et cetera, et cetera, et cetera. Another classic primary versus excess, somewhat related to that, is a failure by the primary insurer to settle a claim within their limits. And then the case goes to trial and there is an excess verdict and the primary throws up its hands and says, well, we tried our best. We'll leave it to you, Mr. Excess Insurer, to pay the verdict. And of course, they may be getting their very first notice with the verdict. So there are issues of fiduciary responsibility, claims of lack of good faith, again, all of which are in the context of inter-insurer claims, but again, the subset of primary versus excess. I'm going to grab just a quick sip, and we're going to go on to our last example of an inter-insurer claim, and that is application of self-insured retentions. Some of you in the audience may be familiar with the fact that more sophisticated insureds and corporations may have self-insured retentions or large deductibles as a means of controlling their cost of their particular insurance program. But that leads to battles. Well, how many occurrences were there in a particular loss? How many self-insured retentions or deductibles should be applied? We often see this in the context of, I mentioned CD or construction defect litigation, or unfortunately in this day and age, molestation claims, where we may have a bad actor involved in untoward acts to multiple victims over multiple years. And then how does that all translate out in the context of insurance coverage? Let me move on to underwriting claims, which is our fourth scenario. So again, underwriting claims really being issues that arose due to the manner in which the particular risk was underwritten, fraud in the application, which is probably the classic leading to a rescission action. Again, the classic case being a dispute over whether the insured lied in the application and whether or not that misrepresentation was material to the risk. Of course, the insurer wants to rescind the policy. The insurer wants a declaration that the policy should be deemed void ab initio because of fraud in the application. And as you might imagine, there's an awful lot of risk riding on the answer to that question. It is classically an all or nothing scenario. So something certainly ripe for mediation because there is significant risk on both sides. Another underwriting type claim, we see specified location, scope of work disputes. For example, there could be a loss of some type at an unscheduled or misidentified location on the policy. And then there will be a lot of backpedaling as to how that occurred. Was it simply a ministerial error, or perhaps it could lead to the involvement of the insurance broker on how that came to be? But the insurer, of course, is is positing the position that, listen, we didn't insure this location, it wasn't in the application, we didn't schedule it on the policy, and therefore we have no responsibility for the event that occurred at that location on that given day. Somewhat of an offshoot of that is a misclassification of work. Of course, you see this in the construction field when dealing with contractors' policy. You might have a policy that was underwritten with a classification of the insured performing carpentry work. Well, then you find out wasn't quite simply a contractor. He also did roofing work as part of his business. And again, as you might imagine, a roofer has different and more significant risks from an underwriting standpoint. And the insurer would have said, hey, had we known, we wouldn't have insured this company, or we would have asked for more premium. And now it's being given to us in the connection of a claim of someone who fell off a roof and who's been terribly injured. We want no responsibility for this. We think we have an underwriting defense. So, having identified those 4 basic scenarios and some of the issues you see in each, let me take a minute now and talk about why mediation in particular is an advantageous means of resolving insurance coverage disputes. Let me start with what might be the most obvious. You get to select the mediator, right? This is not a situation where you're in court and you've been assigned to a particular judge who might or might not know the world of insurance law. Mediation allows you to pick someone with experience, someone who understands the issues, someone who appreciates the practical and business concerns of the parties. And let me suggest this to you. If you don't know the particular mediator, who perhaps the other side has recommended as being conversant, or as I like to say, fluent in the language of insurance law, interview the mediator. Ask around. Talk to your colleagues. I think there's great value in asking the community at large, what do you know about this fellow or this gal? What's their experience in the world of insurance law? And again, I can certainly tell you from my own perspective, I'm always happy to spend a few moments on the phone and be interviewed and talk about my experience and part of how, my philosophy in approaching mediation generally and dealing with insurance coverage issues specifically. Of course, the confidentiality. Yes.
I have a question from the audience, and I wanted to dovetail on you're willing to be interviewed at any time, so I'm going to pop in with a question here. If the party knows the case will go to mediation and should be resolved in that forum, please describe the type of attorney that should engage. A pure trial attorney / litigator, a transactional attorney specialist, a subject matter attorney, an academic or well-connected, or an attorney with a charming personality. Seems as though picking the right, quote, tool for mediation is important.
And this question is selecting the attorney to represent the party, correct?
I believe so, yes.
Okay, all right. So, you know what, that's a great question, because ultimately, who you select to be your champion in mediation can be important. I often suggest it not be the trial lawyer on the eve of trial, all right? Why do I say that? Because at that stage of the litigation, that particular attorney is in what I call the trial zone, all right? So for me as a mediator, it's hard to have them accept whatever critique I might be making about their particular case or the issues in their case. And listen, rightfully so. They are in trial mode. They are going to be taking this thing before a judge or a jury in short order. They're not in settlement mode, they're in trial mode. I think I would best answer the question is not necessarily by an academic either, because I think those in the ivory tower don't necessarily appreciate the practical realities of business and the practical realities of litigation. I think if you have a litigator who is not yet in trial mode, who of course is very conversant with the case, the facts, the law, and has a strong relationship with the client or the ultimate decision maker, that's probably the best of all possible worlds as far as having that person be your champion at mediation. So thank you for that question. That really was a terrific question. And you know what? I'm going to let it lead me right into the next point I was going to make, because it's a great segue. When's the best time to mediate? You heard me already say, I think if you're really at the 11th hour, listen, on some levels, it's a good time to mediate because everybody is focused on the absolute risk that faces them if they take this to the brink. Again, my struggle sometimes with the guys or the gals who are the trial lawyers, they may have their trial blinders on and they're not going to be as open to critique and be as flexible as I need them to be. But listen, the flip side is true. You can bring a case in too early as well. And certainly there's always positives that come out of an early mediation, but I have a little saying I use when we're struggling with an early mediation. I'll say, listen, the good news is you're here early. The bad news is you're here early, because sometimes you're too early. I often ask the parties if they're interviewing me ahead of time or in fact retaining me early on, let's get some basic information exchanged. Doesn't have to be depositions, doesn't have to be expert reports, but talk to me about what do you need from a real nuts and bolts perspective to assess your position, to assess your claims, to assess your defenses, because if you come in too early, I can't answer the questions for you. And we're not there to be on a reconnaissance mission or a fishing expedition. We're coming in to negotiate. So often what I'll do is I'll sit down with the parties as a precursor to a mediation, and we'll go through what do the parties need, not what the parties want, but what the parties need. Now, this walks me right into the next topic, and that is preparing for the mediation session in the context of an insurance coverage matter. I am a firm believer that the more you put in on the front end, the more you're going to take out on the back end, all right? Preparation is key. And again, you heard me give an invitation for someone like myself to be interviewed. Even if I've been selected by the parties, feel free to call me ahead of time. Let's develop a rapport. You can talk to me about some of the procedural issues. You can talk to me about some of the substantive issues. Listen, we're allowed to have these ex parte communications, and I encourage the parties to take advantage of it. Like I encourage the parties to spend adequate time on their pre-mediation submissions. Listen, pre-mediation submissions are important. I always encourage both sides to prepare a brief, certainly in the context of insurance coverage disputes. I ask for the policies to be provided with specific reference to the portions of the policies which are at issue. I ask for adequate time, thank you, for me to process the submissions. You know, for me to get a 25-page brief with a 110-page policy next to it at 10 o'clock the night before we are having our session really doesn't help me. I do believe the parties should exchange submissions. Now, I know there's always a little bit of hesitation to that. on the part of the parties. But you know what? On a practical level, I found after having done this for many years, between the opening statements and what's discussed during the course of the day at mediation, the fact of the matter is everything ultimately gets out on the table anyway. So educate your adversary. Listen, more likely than not, what you send in to me with a copy to your adversary is going to get to your adversary's client. Well, that's pretty valuable if you keep in mind you're going to have an opportunity to speak to your adversary's client directly in writing. And that's why I'm also a big proponent of opening statements. There seems to be a little bit of an undercurrent these days where the parties will come in and say, you know what, we know this case backwards, forwards, and sideways. We don't see the need for opening statements. Let's just get down to business. And geez, I tell them, well, I'm glad you guys know it frontwards and backwards and sideways, but I haven't been living and breathing it like you have. And I would appreciate opening statements. And frankly, I will tell you, it's always fascinating to me because what people ultimately submit in writing never really lines up with what they focus on in their opening statements. I always see the focus being a little different. I see nuances that you don't pick up on in the written materials. And again, if you have the decision maker sitting across the table from you, why wouldn't you take advantage of the opportunity to talk to your adversary's client? I mean, it's just remarkable. It's the only place you're going to get a chance to do it. And I think it can be very powerful. Listen, they're gauging you, right? They're looking at you. I wonder if this lawyer's got what it takes to challenge us in this case. They're sizing you up. You know what? Go in there to impress. And I'm going to digress for just a minute because I've got a little bit of a story which I think emphasizes that point. So again, alluding back to my Hurricane Sandy cases, I had one of my matters, probably the one out of the 100 that I'll never forget. And as I mentioned, they're first party cases. We've got homeowner versus homeowner's insurer. And of course, the homeowner's insurer sent in a really high-end insurance coverage firm, and they had a senior partner there, and they had a junior partner there, and they had a young associates there, all ready to do battle. And in walks the plaintiff's lawyer. And I'll probably be giving away my age by telling you this, but this fellow reminded me of Peter Falk in Columbo, in the old television program Columbo. He comes in kind of in a rumpled suit. His papers are in complete disarray. They're all over the conference room table. My 20-somethings would call this guy a hot mess. And he began his opening statement. And as I watched, he starts to tell a tale. And he's kind of rifling through these papers, but he's putting together a story that was remarkable. And he's saying, in somewhat of a self-deprecating way, well, then I found this email. And the email seems to be from the insurance company to the engineer that did the inspection. And it seems like they're trying to get him to modify his findings a little bit. And I wasn't sure what to do with this. And then I compared the two engineers' reports, and I found this change, and one thing led to another. And honestly, I just kept my head down and I was taking my notes because I wasn't trying to react to it. But I'm thinking, holy smokes, this guy is giving his opening statement at trial, and he is building a bad faith case against this insurer right before my eyes. Rumpled suit, disarrayed papers and all. So when we went into caucus, I took the high-end insurance coverage firm into their conference room, and I looked at the senior partner. I said, "Do you know what we're going to do today?" And he looked at me and goes, "We are going to settle this case today." I said, "You're damn right we're going to settle this case today." So anyway, all part of the point that opening statements can be very important and very powerful. Now, in the context of insurance coverage litigation and the issues that we are grappling with, we're oftentimes, as you heard, when we're talking about third-party claims, when we're talking about inter-insurer claims, we've also got the underlying claim there to grapple with, right? And that can be a little bit perplexing at times because often I feel like I'm mediating two separate disputes. And on some levels they are, but on some levels, of course, they are completely interrelated. So it can be a bit of a challenge when you're dealing with the underlying action and the plaintiff's attorney there, and I'm dealing with the coverage guys here and the defense lawyers. So one tool I use, and in fact, I did it yesterday, as a matter of fact, because you always have to be mindful of what's going on in the underlying case. Sometimes I have defense-only mediations where the plaintiff's counsel and his clients in the underlying litigation are not even present, and we spend a day with the defendants and their insurers only. So yesterday, we had a full day session. I had 10 parties and their insurers, and the underlying case was a very large property damage claim that arose out of a very significant construction project in Manhattan, and the defendants were at each other's throats. The insurers for the defendants were at each other's throats. So rather than have plaintiff's counsel come with his clients and frankly probably spend the better part of the day off by themselves without me being able to engage with them because I'm busy fighting all these flank battles, I had the defendants and the carriers come in, and we spent the day, talking about the underlying case, talking about what they could agree to as to what a reasonable settlement value might be for that underlying case. And then we spent our day building a model, building a funding mechanism. In other words, if we had to get to X number of dollars as the high watermark to settle this case, what are each of you going to do as part of that process? Now, easier said than done, because those of you who have been involved in litigation involving multiple defendants, is sometimes the defendants are their worst enemies, and they're so busy looking at what this guy is doing or what that gal is doing or what their carrier is doing or what their client is doing, that they lose sight of the bigger picture because they're completely obsessed with what the other parties are doing. So, in other words, well, if he's only going to do this, well, I'm not going to do that. So what I did yesterday, and I employ this sometimes too, particularly when we've got the underlying insurance coverage issues, is I utilize blind bidding. So what I did yesterday was I spent a good chunk of the day kind of coming to terms with everybody, and they all didn't agree, as you might imagine at first, but coming to terms with everybody as to what the settlement pool should look like. How large should it be? Obviously, they hope to save something off it, but be realistic, and we finally got to a number, right? But then I was working with them individually, and I wasn't telling the others what each one was willing to put into the pot, but I would pull them back together every hour and a half and say, okay, gang, we are at 79% of our goal number. Now, they didn't know what each one was putting in percentage-wise. I need you all to go back to your respective decision makers. Round two. All right, I'm happy to report we're at 84% of our goal number. And we kept working and kept working and kept working until we finally hit the 100% mark. And frankly, they still don't know what the others are putting in the pot. But I would encourage them, I'd say, listen, don't get so focused on what this guy is doing or that gal is doing. What is your risk? What is your exposure? What are you willing to do to bring this thing to an end rather than engage in fighting with co-defendants and with insurers on risk transfer issues or priority of coverage issues? And that's how we ultimately were able to move things forward. And as you might imagine, now the next round will be with plaintiffs' counsel in the room, and the 10 parties have an understanding, and it will essentially be a united front, a one-on-one, to try to get the case settled. In the context of yes.
Oh, sorry. I had a question come in about opening statements. Do you want to walk back a little bit? Okay,
of course.
Have you come across opening statements creating hostility between parties because one side takes offense to what it said? How do you avoid the, quote, heat caused by opening statements?
Oh, all right. Terrific question. So there is an exception to my general rule. All right. And the exception is if opening statements are going to cause consternation, upsetment, or be disruptive. All right. So if I get a call in advance and say, Rich, listen, I know you like to have opening statements, and 9 times out of 10, I'm with you on that. But I have to tell you, we have been at each other's throats. The clients hate each other. We don't even know if we can get them to sit in the same room without opening statements. So, of course, that's my signal not to push the envelope too far. Where do I see that? I see that in employment cases. All right. We may have a plaintiff in a discrimination case or harassment case who is incredibly uncomfortable from sitting across from his or her former boss and listening to opening statements. I get it. Business dissolution cases. We may have partners who are in the process of winding down a business. They can't even look at each other without getting angry. So yes, there are always exceptions to the rule on the front end. And to maybe answer the question more specifically, Jen, when I'm a referee, right? At the end of the day, I've got to keep everybody in balance. I have to make sure things don't get out of hand. If I do start to feel the heat, as our questioner aptly described it, you know what? I call a timeout. I put the parties in their respective corners, and maybe we've taken the openings as far as we can. So again, good question. It is something I have to be mindful of. General rule, yes, for the reasons I mentioned, opening statements, but of course there's an exception to every rule, and that would be the exception. So we're getting a little bit into strategy, which again is a good segue for me. One of the things I encourage parties to do, because the mediation process is confidential, and again, listen, that's the bedrock of what we do, frankly, and I think you all appreciate it. I know the attorneys that I work with really respect it and honor it, and frankly, I couldn't do my job properly without everybody honoring the confidentiality of the process. But it lets us explore positions. It lets us test boundaries. And one of the things I encourage the parties to do, again, in mediations generally, but certainly in insurance coverage cases, is, you know what, acknowledge your weaknesses, right? I think as lawyers, sometimes we're trained, we don't give an inch on any issue. We are here to fight to the death on every single issue in the case. You know what? That's great at trial. It may be necessary at trial or arbitration, but it's not great in mediation. I would much rather have someone come in and say, listen, these are my top 3 arguments. I understand I have arguments 4, 5, and 6. I'm going to put those to the side for today. I'll tell you confidentially, they're not my strongest points. So I want to focus on my strengths. And I think that's really the flip side of acknowledging weakness in the context of a mediation. It allows you to emphasize your strengths. It ultimately builds your credibility. I think with the other side, certainly with me, it shows me you're prepared, you understand your case, you understand where your strengths lie, you understand where your weaknesses lie, and you're going to use the most out of our time together by focusing on those strengths. Coming in from a preparation standpoint as well, listen, nobody likes last-minute surprises. If there are any issues you need to get on the table, and it may be something as mundane to you as terms of payment, confidentiality provisions, liquidated damages clauses. You know, as I always say to parties, those, you work all day, you're right at the end of it, you think you've got a deal, everybody's exhausted, and then somebody says, oh, by the way, I need blank. And the other side goes, poof, and you know what? And then the gloves come off and we're right back at it. So what I do encourage parties to do as part of preparation, and again, this comes back to my theme that preparation is really critical in the mediation process before you arrive. If there's anything you need at the end of the day, get it on the table early. Nobody wants any last-minute surprises. Nobody wants to hear an oh, by the way moment at 10:30 at night when we're exhausted. Now, some attorneys will say to me, well, I didn't want to tell you earlier because I didn't want them to think we were coming here to settle. They might think I'm weak. They might take advantage of it. You know what? I don't necessarily believe in that, but I understand it. So what I tell people who are concerned about those optics, let's call it, is tell me, all right? And I'll go into the other side and I'll raise it and I'll say, oh, by the way, do you need anything at the end of the day if hopefully we get this resolved today? And I'll go into the other side. And you know what? And let me put it on the table because it's so much more of a positive factor to get it out there, because then it does become, I won't say a non-issue, but it's not going to become an outsized issue when it was brought up at the 11th hour. Another issue we might encounter at the 11th hour is an impasse, right? Everybody's getting tired. Everybody's running out of gas. What do we do to try to keep the dialogue going so people just don't pack up their briefcases and walk out? Well, again, that's where the confidentiality of the mediation process becomes important, because look, we can explore different scenarios without people committing to something particular where they feel they might have compromised themselves for the future if for some reason we don't get the case out. I'm a big believer in conditional offers and demands. Some people call them brackets. I do not, because I think people just have a visceral reaction to that verbiage. I call them conditional offers and demands, as simple as defendant will go to X if plaintiff comes down to Y, and if plaintiff says yes, defendant will make the next move. It lets us explore. It lets us test boundaries. Plaintiffs can come back with the flip side, with a conditional demand. You know what? I don't like that conditional offer, but I will reduce my demand to X if they come up to Y, and if they say yes, I'll make the next move. So you know what? Everybody is able to do the dance with one another without someone putting a hard offer or a hard demand on the table that they might not be comfortable with. If it has to live on past the mediation process. So again, I think that's one way to avoid the impasse. Another little analogy I use, I'll tell you, it's a terrible analogy, but I use it. Sometimes I say to the parties, listen, would you put your toe on the 1 yard line at $750,000 if they would put their toe on the 1 yard line at $3 million, and then we've got the 2 goalposts planted, I blow the whistle, and we've got a contest somewhere between those 2 goalposts, right? It's a horrible analogy, but it gives a little bit of a visual. It lets people talk to me without committing. It allows them to explore what the other side might be willing to do. And frankly, the reason I use it is because it works. It lets us bring the goalposts in to some degree without anyone ultimately getting married to a position, and it lets us avoid the impasse. One tool that some mediators use, and I'm going to mention it only because I do not, is a mediator's proposal. And again, I'm not putting the knock on any mediators who make use of it. I'm sure you have familiarity with it, where the parties come to the mediator at the end of the day and say, listen, we're just at loggerheads. We would like you to make a mediator's proposal. And I always say no. Why? Because it's me weighing in on what I think the case is worth. And I do not weigh in on what the case is worth. I don't think it matters a hoot what I think the case is worth. And when people say to me, and of course they say it many times each week, well, what do you think the case is worth? I'll say it doesn't matter what I think the case is worth. If you want to ask me what I can settle the case for, that's a different question, and that's one I'm willing to weigh in on. The struggle I have with the mediator's proposals is somebody generally walks away holding it in a death grip. From now till kingdom come, well, this is what the mediator said the case is worth. I've done myself an injustice. I've undercut my ability to settle a case. And again, others make use of it, and I'm sure quite well and quite successfully. I just do not. All right, so I see we are getting close to the end of our time together. So I just want to talk about one final subject, and that is documenting the terms of settlement at the conclusion of mediation. I'm sure those who are listening in have often come away from a mediation with an understanding of how the case was settled, what the basic terms were, and are quite comfortable as they head home that evening, until they find out that's not the way the other side remembers it. As I like to say sometimes, people think they understand the terms of a deal until they don't. And that's a shame. So I've, of course, look to have the party sit down, as tired as they may be. And listen, I will act as the scrivener, but we will put together some type of a writing before the parties leave, because I ultimately want there to be no issue after the fact. I can tell you I had a very large fire case probably 4 or 5 weeks ago. It was 9:30 at night. We finally got it done. I kid you not that we spent the last 2 hours hammering out 2 paragraphs as to what the tenant was going to do on a going forward basis relative to the safe storage of flammable materials at the property he was leasing from this municipal entity. And oh my goodness, it was going back to the general counsels for the municipal entities. It was going to this client's personal counsel. It was going to his insurance company retained defense counsel. But you know what? I'm glad we did it, because I heard last week there was some grumblings, and someone called me, well, I thought we did this, I thought we did that. I said, wait a minute. I said, did we not spend from 7:30 till 9:30 that night banging out those 2 paragraphs? That's it. You agreed to it. You signed it. Maybe you came away with a little bit of a different impression, but you know what? Shame on you. And I was told afterwards, you know what? They ultimately closed it using that language, even though there was some turbulence at the end. So my message to you all is, as tired as you may be at the end of the session, and as clear as you may think you have in your mind as to the terms of the settlement, just like you put all that effort in up front, put that extra effort in at the back end, document it, It's important. All right. And on that note, I'm going to conclude my remarks. I want to thank you all very, very much for joining me this afternoon. And thank you, Jen, and thank you, CCBJ. And most importantly, of course, everybody out there in these very strange and unsettled times, stay safe, be healthy, and somehow, some way, we're gonna get through this thing together. So thank you very much for your time this afternoon. I really appreciate it.
Thank you, Richard. Thank you, everybody else, for joining. If you want an on-demand version of this, we will be sending around a link tomorrow morning. But again, thank you, Richard. Thank you, Nam, and have a great day.